Good afternoon, everyone. Welcome to this webinar presented by members of the 39 Essex Chambers Fire Law team. This team is comprised of members of chambers who specialise in property damage, construction, property, insurance, inquiry and regulatory law. It's amazing that so many hundreds of you have chosen to give up your lunch hour and be with us today. And thank you very much. The webinar is being recorded and a link will be sent out to everyone who's signed up tomorrow, and it will also be available to watch on our website. There's the usual question and answer box, and if you have a question, we will try to deal with as many as possible at the end of the session, and if we don't get to your questions, then it may be possible to answer them by email or some other means in due course. I'm Neil Block, a silk whose practice spans all aspects of our fire law work, and I'm delighted to introduce to you the members of our panel today. Paul Darling QC, he's a construction and commercial practitioner with recent experience in fire cases and on their impact on construction contracts, the impact of fire approvals and regulations. He's a general editor of Wilmot Smith on construction contracts, which, as you would expect, is soon to be known as Wilmot Smith and Darling on construction contracts. Next is David Sawtell. He's a construction and property specialist. He has a heavy caseload dealing with cladding and other fire safety related issues, both construction and property related, and in respect of residential and commercial properties. And he's acting for a core participant in the Grenfell Tower inquiry, and he researches and writes academically on the issues that we'll be looking at. Next, Samantha Jones. Sam has been practicing for 10 years or so in civil, commercial and regulatory law, and most notably she's been acting for the Grenfell Tower inquiry as a lead junior counsel led by Richard Millett QC, and she's been focusing on the construction, building defects, fire risk assessments, fire safety breaches and health and safety management. Last but not least is David Hopkins. He was called to the bar in 2013, and he's got a thriving construction practice acting for employers, contractors and other parties. He regularly appears both on his own and is led in the TCC, and he has been instructed in the Grenfell Tower inquiry since 2018. The format for today is loosely akin to a roundtable discussion, and I'm going to have to corral these very difficult people into behaving themselves and waiting for their turn to speak. A very brief introduction. The Building Safety Act 2022, as you know, has taken some time and much work to reach the stage of Royal Assent. It's said to take forward the government's commitment to fundamental reform of the building safety system. And in particular, it's intended to reflect the lessons learned from the Grenfell Tower fire and to remedy the systemic failures identified by Dame Judith Hackett after the fire. There's to be greater accountability and responsibility for fire and structural safety issues throughout the life cycle of buildings, and in particular through a new regulatory regime for building safety. A building safety regulator will be appointed in England to oversee a new, more stringent regime for higher risk buildings and to drive improvements in building safety and performance standards in all buildings. There's to be a stronger voice for residents, additional protection for leaseholders in relation to financing the remediation works, increased access for redress through the Defective Premises Act, significant changes in limitation law, a cultural change in the industry, so we're told, a stronger fire safety order, and a stronger and clear framework for national oversight of construction projects. So with that very brief introduction to the Act, I'm going to ask David Hopkins to say a few words to you, giving you an overview of the Act. So, David.
Neil, thank you very much. So there's no way of sugarcoating it, I'm afraid. There's a lot to deal with in the Act. There's 6 parts with 171 sections. There are 11 schedules to the Act, the longest of which has 90 paragraphs. And indeed, the regulations which are going to be made under the Act number in at least 8 sets. And we can expect those to be made over the next 18 months or so. I'm going to try and whiz through the key features of the Act for you, which perhaps might be called setting myself up to fail, but we'll see how it goes. Fortunately, part 1 of the Act is helpfully simply an overview and provides a bit of a contents page, which the drafts person can be lauded for. Hopefully more Acts will be like this in the future. Moving then on to part 2, which makes provisions for the new building safety regulator that Neil mentioned. The building safety regulator's functions are said in part 2, or sorry, the regulator is said in part 2 to be appointed as the health and safety executive, and the HSE is obviously currently preparing for that role. Moving on to part 3 makes amendments to the Building Act 1984. Those amendments are not yet in force, and I'll go on in a few moments to explain the transition plan for the Act. But part 3's amendments to the Building Act, when they're brought in, will include that the new regulator, the HSE, will be the sole building control body for higher risk buildings in England, and also introduces a new gateways process for building control approval of higher risk buildings. First question, of course, is then, what is a higher risk building? In part 3, section 31 inserts a new section 120D into the Building Act, and it defines a high risk building as a building in England which is at least 18 metres high or is at least 7 stories and is of a description specified in regulations made by the Secretary of State. And the draft regulations, which were previously on the government's website, stated that the following descriptions of buildings are high risk buildings, and that is a building with at least 2 residential units, a care home and a hospital. And presumably, of course, they also need to be at least 18 metres high or have 7 stories. The new gateways, in terms of building control approval, are introduced at key stages in the design and construction of higher risk buildings. Gateway 1 has in fact already been enacted under delegated legislation under the Town and Country Planning Act, and that's intended to ensure fire safety matters are considered at the planning stage. Gateway 2 is a stop-go, as it's called, decision point, and has to be passed before development can proceed. And Gateway 2 occurs before building work even starts. The person doing the works must get building control approval from the regulator before proceeding with any of their construction works. And then Gateway 3 occurs at the time the building work is completed, and building control approval must be obtained from the regulator, the building safety regulator, before registering the building and commencing its occupation. Moving then on to part 4. Part 4 deals with the next stage following completion and occupation of the building of a higher risk building. Part 4 identifies new duty holders who are called accountable persons rather than the responsible persons we've seen under the fire safety order. The accountable person in most cases will be the building owner, but it is possible, of course, that there might be more than one accountable person, such as someone who has repairing obligations under a lease. In those cases, the Act provides a method of deeming who is the principal accountable person. The accountable person's statutory obligations include registering the building with the regulator, and before that's done, the building cannot be occupied. Existing buildings will also need to be registered. The accountable person must also apply for a building assessment certificate if requested by the regulator. And the accountable person's key duty is to assess building safety risks and take all reasonable steps to prevent the occurrence of or control the impact of a major incident. The accountable person will demonstrate compliance with that duty by producing and maintaining a safety case report. A final nuance in this part is that, in fact, the definition of high-risk building for these purposes, that is, once it's occupied, is in fact slightly different to that in part 3, the building control section, if you like. In part 4, for occupied high-risk buildings, a high-risk building then is one which is at least 18 meters high or has at least 7 stories, just like in part 3, but in this case, specifically contains at least 2 residential units. Now, under the regulations in part 3, that is also the case, but here, at least in the draft regulations, care homes and hospitals have been excluded. That might be perhaps obvious in on reflection, given that care homes and hospitals are of a different class to an occupied residential building. Part 5 then, moving on from part 4, is a fairly wide-ranging set of other provisions, and that deals with, among other things, the remediation of certain defects in buildings which are at least 11 meters high or at least 5 stories. It makes some amendments to the Defective Premises Act and amendments to limitation periods, introduces a new homes ombudsman, and also makes amendments to the Fire Safety Order and the Architects Act. It finally also includes construction products provisions, including liability of manufacturers and suppliers, and in particular, I would direct the audience's attention to section 149 on cladding products, which makes cladding manufacturers and suppliers liable in certain circumstances.
Thank you. David is going to go on to talk about the new planning regime, but a number of you are finding it difficult. There's some feedback on David's line, so I'm going to give him a moment to try and sort that out, and I'm going to move on to David Sawtell. And David, what's the position with regard to the Defective Premises Act, which I think many of us have thought historically has not been of much value to property owners and occupiers? Is that now given more teeth?
I mean, absolutely. The overall policy of the Building Safety Act has been to improve safety to high-risk buildings, new and existing, and to pass on costs to developers and builders. And the way in which the Defective Premises Act has been amended and limitation has been amended under the new Act is very much part of that scheme, both by increasing the potential for liability, but also increasing the potential number of defendants. And this is mostly contained within Part 5 of the new Act, which has a range of schemes to try and improve both of those features. The first point I'd make in terms of increasing the number of potential defendants is in respect to building liability orders. This gives a High Court a power to make a building liability order if it considers it just and equitable to extend liability under the Defective Premises Act 1972 and Section 38 of the Building Act 1984 to associates. And they're defined as Section 131 as being one company owning or controlling it, one company controlling the other, or a third body corporate controlling both of them. So immediately the number of potential defendants to claim under the 72 and the 84 Act increases. We're going to look in a moment at the Section 38 of the Building Act, because as we know, that's been in the statute book for some time, but now the government finally wants to bring it into force. And that's going to be quite an important development. But it's in respect of the Defective Premises Act that we see most of the heavy lifting being done to increase liability on those involved in construction of dwellings. There is going to be a new Section 2A to the Defective Premises Act 1972. The lacuna in Section 1 of the 1972 Act was that it only applied to the provision of new dwellings, and that was interpreted really quite restrictively in a line of cases. Section 2A quite dramatically expands the scope for liability by expanding liability to include those persons in the course of a business who take on work in relation to any part of a relevant building. Relevant building is used many times in the 2022 Act in different contexts. And in this context, it means a building consisting of or containing one or more dwellings. And that's owed to the same class of persons that you would expect to see under Section 1. So person for whom the work is done, and each person who holds or acquires an interest in a dwelling in the building. And again, the same test of fitness for habitation. One of the key points, though, about this is if the builder or the person carrying out the work is simply following instructions, then their liability will be discharged under Section 2A. This new duty is prospective. It's not being imposed retrospectively. The retrospective element to this part of the Act comes in the new limitation periods. And it's probably in respect of this that many of us have found ourselves advising over the weekend now in terms of how our existing cases are going to be affected by the retrospective effect on limitation. There's going to be a new Section 4A to the Limitation Act 1980. So looking prospectively at claims under Sections 1 or 2A of the 1972 Act and Section 38 of the Building Act, there's going to be a new limitation period of 15 years. But where you have a claim under Section 1, so the one which applied originally from the 1972 Act, a person became entitled to bring an action, then the limitation period will go up to 30 years. That's a very long period of time. That's going to be subject to two defences. First of all, the claim has been settled or finally determined. So a claim you've settled can't be revived. The other point is where an action is brought, a court must dismiss it if the court thinks it's necessary to do so to avoid a breach of that defendant's convention rights. So looking at the European Convention on Human Rights, if the court considers those rights have been infringed by the introduction retrospectively of a new limitation period. It's highly unusual for an act to operate retrospectively, and highly unusual as well for an act to refer explicitly to an interference of convention rights as being a defense. So I suspect that indicates how unusual this provision is. There's some commentators, such as Douglas Maxwell and Sue Bright, who've written on this point, who consider it should not interfere with convention rights, but this is going to be something for debate in the case law. Section 38 of the Building Act 1984, the government plans to bring into force at around the same time as these new provisions come into force, i.e. we're looking at 2 months after commencement of the Act. That seems to be restricted on government's interpretation to breach of a duty imposed by building regulations insofar as it causes damage. And the government expects that damage will be interpreted restrictively so as not to include pure economic loss. So that's going to be an important feature in that the Defective Premises Act will apply to financial loss, whereas a Building Act will apply to property loss. So circling back to your question, Neil, there's certainly already been given a huge amount to think about in terms of existing and prospective claims, which tie back into how do we ensure, as far as possible, costs not being passed on to the owners, in particular leaseholders of defective premises. I think you're on mute, Neil.
Neil, you're on mute.
I'm sorry. That was an introduction into how claims may be affected, and we've received a lot of questions in relation to how the new limitation period will act, particularly with regard to claims that would be already statute barred, but we'll try and deal with those at the end if we have time. But I wonder, moving away from claims to the regulatory changes, Sam, those are wide ranging. Could you give a brief introduction of those, please?
Yeah, of course. Thanks, Neil. Yeah, so as Neil and David Hopkins explained at the beginning, the major part of the Building Safety Act is the introduction of the Building Safety Regulator, which is going to sit within the HSE. And as I heard from a senior member of the HSE last week, they have 12,500 buildings in their scope as the Building Safety Regulator. And they are hoping to get started with setting up the powers and to press the button on establishing it next April. So there's not actually that much time before this regulator becomes a probably weekly, if not daily feature in our lives in the building safety industry. In terms of the aims of the regulator, there are three of them. The first is to oversee the safety and standards of all buildings, and that will include overseeing the performance of all other building control bodies and building control approvers, previously known as approved inspectors, and advising on emerging risks and possible changes to the building regulations. The latest I've seen on the government website is that the government envisaged that the functional requirements for building works will remain the same as in the Building Regulations 2010. So this is more affecting the procedural side of it. The second aim is to assist and encourage competence in the built environment industry. And in respect of that, they'll be leading the industry with an industry competence committee. Now, that committee is going to be established to monitor industry competence, advise the regulator, and advise those in the built environment industry. As I understand it, this is going to have quite far-reaching powers to establish and regulate competency standards for a whole host of professionals who are involved in the built environment and construction work. So it's certainly something to keep an eye on. Then the third aim is to lead the implementation of the new regulatory framework for high-rise buildings, including becoming the building control authority for work relating to higher risk buildings. Now, as you've already heard from David Hopkins on this, it will be the building safety regulator who you will have to go through in respect of all the building control work, and applicants will no longer be able to choose their building control body, which I know will come as a disappointment to many. The building safety regulator is going to be responsible for all regulatory decisions under the new regime for the design, construction, occupation, and refurbishment of high-risk buildings. I think the question that probably is on all of our lips is, how the heck are they going to do this? It's an enormous task that they are facing in a relatively short amount of time. One thing I wanted to focus upon was the enforcement powers that the new regulator is going to have, if we have a moment. It's pretty interesting to look at the Act, in as far as that is ever interesting, but the enforcement and prosecution powers that will be available to the BSR are quite significant and something that you'll want to going to be mindful of when advising clients. Now, the purpose of strengthening the enforcement and prosecution regime came from Dame Judith Hackett's findings that there was inadequate regulatory oversight and enforcement. And where enforcement was necessary, it was often not pursued, and the penalties were so small as to be an ineffective deterrent. Well, I can tell you they have certainly tried to address that. Now you want to look at sections 39 and 40 of the Building Safety Act. What they do is they amend sections 35 and 36 of the Building Act 1984. Just taking them in turn very briefly. Section 39, which deals with Section 35 of the 1984 Act, the offence of contravening building regulations. Previously, you could only be subject to a fine in the magistrate's court, but now the person liable may be subject to imprisonment of up to 2 years, or a fine, or both, and you could be tried in the Crown Court. That may come as either delight or disappointment to a number of us. Secondly, Section 39(3) extends the time limit for Section 36 notices from 12 months to, get this, 10 years, meaning that you could get a notice 10 years after completion of building work. I find that personally astounding, but there we are. Section 40 inserts a new section into the 1984 Act. And it's particularly something that you'll want to be aware of, because it states that if an offence is committed by a body corporate with the consent or connivance of a director, manager, or other similar individual, or is attributable to their neglect, that individual may be prosecuted as well as the corporate body. They've essentially borrowed this wording from the Health and Safety at Work Act. So that is a new way of prosecuting individuals in companies when the corporate body is being prosecuted as well. Then just quickly turning to the timelines for setting up the BSR, as I've said, April 2023 really is the go live date. That's when building registration will open. And as I understood from the talk I saw last week, I think a number of the other powers will start to come into effect then as well. And then from April 23 to October 24, there'll be a number of deadlines for registration of existing occupied buildings, and then deadlines for building inspectors and building control approvers to all be registered through the BSR. So that's just a whistle-stop tour for you there, Neil.
Thank you, Sam. I hope that hasn't given any of those of you who are eating your sandwiches whilst listening indigestion as to the possible consequences of the actions of yourselves or your clients. Well, David has, I think, sorted out his transmission difficulties. And David, there's a new planning regime that's provided for as well, isn't there? And some gateways that have been provided. Could you just give us a whistle-stop tour through those, please?
Yes, of course. Hopefully the sound is fixed now, and you can.
Yes, it is.
Fine. Good. So what I was hopefully trying to say through the interference, I was trying to take you through the gateways that have been introduced in terms of building control. Now, Gateway 1 is already dealt with elsewhere under Town and Country Planning Act delegated legislation, and that's intended to ensure that fire safety matters are considered at the planning stage. But there are then two gateways in the new Act, which are essentially stop-go decision points. And the first is Gateway 2, which must be passed before building work starts. And building control approval must be obtained from the HSE before any relevant building work starts for a higher risk building. And then once the building is complete and practical completion is due to occur, Gateway 3 requires the regulator to again approve and sign off, effectively to stop value engineering and changes of materials leading to something being built which wasn't approved. That's the basic structure behind the idea of Gateways 2 and 3. Before Gateway 3 is passed, the building cannot be occupied and practical completion can't occur effectively. Neil, I was going to go on once I'd finished that sort of overview of the Act to the transition plan, which possibly is a useful thing to do now.
Yes, please.
Notwithstanding the fact I've already had technical difficulties, I'm going to attempt to share a screen, which let's see how that goes. So this, which you should hopefully see now, is the government's outline of how the various provisions of the Act will be brought in. What's currently in force since Royal Assent is effectively just a handful of provisions, mainly definitions and enabling legislation. You'll see on this map, Royal Assent is the first circle in, or sorry, second circle in red, and that occurred on 28th of April this year. This diagram is slightly outdated in that it says that Royal Assent plus 2 months, and it refers there to the limitation period of the Defective Premises Act being extended. In fact, actually, Act now provides, section 170, that various other things will also come into force 2 months after Royal Assent. And that's about a month from today, 28th of June, in addition to the amendment to the limitation period of the DPA. Also, the provisions for remediation of certain defects in buildings which are 11 metres or 5 stories high or greater will be brought into force in 2 months' time, as will the provisions regarding construction products, including cladding products, and also the construction products regulations that are set to be made. Also, the amendments to the Architects Act, which the Building Safety Act introduces, mainly to do with architects' disciplinary matters, they will also be brought into force in about a month's time now. You'll then see there's effectively a bucket of other provisions that are brought in between 6 and 12 months from Royal Assent, so over the next 11 months or so. Those include the establishing the resident panel as part of the new regime, and also the changes to the fire safety order. Then in the middle of the page, you'll see the mark of around a year after Royal Assent. And that's the point at which the government intends to start bringing in the main regime. That will include establishing the Building Advisory Committee, which effectively replaces the Building Regulations Advisory Committee, and also setting up the Industry Competence Committee, which Sam referred to. The new gateways I was just talking about for building control are due to be brought in as well in that period. So we can expect those to be brought in, approximately speaking, sometime from April next year onward, and probably before October next year, because that will be 18 months. There'll also be the introduction of the golden thread from Dame Judith's report, and also the new duties on accountable persons to assess risks and manage risks in high-risk buildings.
Well, thank you, David. That's really helpful. And we've got a question that it might be sensible to do with now, which is, where can this useful document be found, please?
It can be found on the government website. I will post in the Q&A a link to that so that everyone else can access it. As I say, it's slightly outdated now, but only in respect of the Architects Registration Board powers and construction product stuff, which you can see in the 12 months period, which in fact is now going to be brought in 2 months, but I will post a link to that in the Q&A.
Thank you.
I will stop sharing the screen, and just to finish off, on transition and extent of the Act, in terms of its territorial and jurisdictional applicability, it's important to recognise that the Act, in the main, applies only to England. There are some provisions which apply across the whole UK, including the architects' provisions and the construction products regulations and new homes ombudsman. But otherwise, the Act itself extends only to England and Wales. But in fact, in terms, the Act expressly refers to, for example, the definition of high-risk building is only in England, whilst leaving the Welsh government to implement the regime as it sees fit. So for the most part, the core of the Act applies only to England.
Thank you. David Sawtell, one of the things that comes up from the discussion so far is that we have to consider the effects on leaseholders and whether they're in a different position than others. What's the position there?
I think this is one of the most important parts of the Building Safety Act, and where the largest amount of hope has been placed. Dame Judith Hackett's report dedicated Chapter 4, for example, to the resident's voice, and the idea of engagement in respect of building safety and particularly fire safety. And it permeates the whole regime of the Act. So when we look at considerations such as the Defective Premises Act, part of the ambition in that is to take some of the financial costs from leaseholders of remediating buildings and to place it back on to developers and builders who were responsible for it. Now, whether or not the Act succeeds in that ambition is a question for another day. but I just want to go through and look at how some of those aims and ambitions are implemented in the Act. First of all, Building Safety Regulator. As you've heard, there's going to be a residents panel that the Building Safety Regulator must establish and maintain a committee of residents of higher risk buildings to give advice about matters connected with a regulator's building functions. And I think it's going to be an important part of the regulator's obligations is to listen to those concerns. Mostly we find the provisions in respect of leaseholders in Part 4 of the 2022 Act, where it makes it clear it's about the management of building safety as regards occupied higher risk buildings. It imposes a number of documentary, bureaucratic and regulatory obligations on different classes of person, and in particular on what's called the accountable person, and one of whom will be the principal accounted person. And one of the issues is going to be, it's often going to be the leaseholder who's going to pay for the cost of this regulatory compliance. Is it actually going to improve fire safety in return for that enhanced cost? The original proposal included the role of a building safety manager, but that was deleted from a final version of the legislation. As you've heard from David Hopkins, there's still some controversy as to what buildings will be caught by Part 4, the definition of high risk building. And the National Fire Chiefs Council, for example, had lobbied to reduce the height from 18 meters down to 11 meters, and that's a possibility. And there's also been exclusion of care homes, hospitals, and secure residential institutions. It's not quite clear why some of those exclusions should be there, but those are only in draft regulations at the moment. The Office of the Accountable Person is going to be critical. They are someone who holds a legal estate in possession in any part of the common parts, or have a repairing obligation, a relevant repairing obligation in relation to any part of the common parts. And if there's more than one of them, then we have to look to the principal accountable person as a person who holds a legal estate in possession of the structure and exterior or relevant repairing obligation in relation to the structure and exterior. And of course, there might be a number of persons who have that, and the Act doesn't give any real guidance as to who might be the principal accountable person. Instead, it's going to be left to the first-tier tribunal to make a determination as the tribunal considers appropriate, which is echoes of a regime for consultation for building works to residential leasehold premises and service charge obligations, which, as we know, was resolved by the Supreme Court in Dacian Investments and Benson, where the court had to create a set of criteria where the legislation failed to provide one. So I suspect we'll be looking out for FTT and upper tribunal decisions in the near future.
Well, thank you, David. There's plenty for leaseholders to chew on there, and I hope that that brief introduction has sent them scurrying for the Act. Now I have a challenge for Paul Darling. I know he's up to it. Paul, tell us about the implications for the market in no more than 10 minutes.
No more than 10 minutes, that's the challenge.
Yeah.
You've just seen from, and I hope I am up to it, you've just seen from the range of those three, if I may say so, with respect, excellent presentations, the sheer range of the activity that this bill involves. And David Hopkins' sharing of his screen of the transitional matrix, you won't very often see transitional provisions of that complexity. The reason you have is there are so many provisions to implement. So the first point I would make is that there is an awful lot to this, and we scratched the surface, but there's going to be lots and lots of work and learning to be done. Those of us who've followed and given lectures on the bill as it's gone through have seen massive changes as the bill went through the two houses of Parliament. But for me, the biggest implication of this is by far and away the largest and most serious statutory intervention in the construction industry ever. And it has, in my view, dramatic effects. Now, everyone always says when new legislation comes in, well, it won't be quite as dramatic as you think. And oddly enough, we have one illustration where I think that is right. But overall, this bill is this act rather is changing the whole position fundamentally. The illustration where it won't make as much difference is the implementation of the civil liability for building regulations, which, if they can confine that to economic loss, will probably have the same impact as negligence. So I don't think that should be regarded as massive. But in liability terms, it's the DPA that brings in all of that brings in the most dramatic changes. First point to make is that Neil, and you said in your introduction, rightly so, that the effect of the DPA was in practice had been nothing like as large as one might have expected when it first came in. We weren't in practice then, but we were in practice in the 90s, and when people were suing under it, and it was a very toothless legal device. But in fact, what has happened is that the changes that the government have brought in have made this dramatic. What they have done is they have extended the nature of the duty, the extent of the duty, and the limitation period for existing and previous claims. And David went through those, and they are unheralded. Now, there are going to be challenges, and I just mentioned three that people may take advantage of so as to be able to avoid the impact of the Act. The first is that they expressly reserve the human rights challenge, and I think it's our public law colleagues in 39 will no doubt be much involved in those sorts of challenges. Second, they've also left open the big question for me as to whether or not what the standard is, because it refers to completion, to the standard of completion, and therefore there's going to be a massive argument, in my view, about what's fair wear and tear. And thirdly, there's going to be quite a lot of argument, I expect, about what claims which have been settled and into which category they come into. People will also be using the Contribution Act to a much greater extent, but for me, this has to be regarded as a really major impact upon civil liability for dwellings. Now, of course, the other factor for the construction industry, of course, it is going de facto to be much more heavily regulated. Wherever you look, there is regulation. The gateways for approvals, all of which appear to have teeth, and Sam managed to sort of say in 2 sentences things that, just change the regulatory regime completely, and gives teeth to it. I think that the industry has to recognise that this is going to be a major impact upon the way in which it works. It's going to change procurement methods because, for example, variations during the course of a contract are going to be much more difficult to implement, because they have to go through approvals processes. In my view, it's going to give the design and build model a greater lift, because it'll enable design to be done first and build second in a different sort of way. And I think all of those will take a long time to work through. You also, I'm afraid, for those of us who have practiced for many years looking at loopholes, if you look at the legislation, what it does is it looks for every loophole available and tries to close it in advance. For me, having argued some of the cases on assignment and no loss, the Linden Gardens case and the McAlpine and Panatown cases, where we were able to persuade the House of Lords, as it then was, that there had been in those circumstances no loss because of the corporate veil. Well, don't worry about that anymore. If you go through the Act, the words that persons associated with you. So if you do something wrong, then in some circumstances, obviously they're very complex provisions, persons associated with you become liable. Now, interconnected companies are going to have a much greater cross liability in certain circumstances, but of course that won't matter, because most of the directors will be on the way to prison with their bags as a consequence of the detail of it. So then you see the horror for the contractors. and it will take working through. But you then do, I think, also see much greater rights for leaseholders. You said, Neil, and I with respect agree, let's see how it works out in practice. But this is giving leaseholders and building owners as well real rights that they would not previously have had. So for me, it's all pretty dramatic. I think that when you have, it's well known that tombstone legislation, as it's ghoulishly called, is very often ill thought out and bad. I was myself chairman of the body set up after Hillsborough, and one had to work through all of the changes. I think this legislation, whilst triggered by Grenfell, and in my view, a concern at the construction practices of some of the major house builders, that this legislation actually has been very carefully thought through. I think the government has, to its credit, not just simply waited for the end of the Martin Moore-Bix inquiry, but has decided to act. It was then a good debate process in Parliament, but what we're left with is a very heavy and complex act. And my view overall is it is an act that is going to impose massive responsibility and liability upon the construction industry. I think that's 9 minutes, Neil. So is that all right?
It's very good, and you've given us the news that there's going to be lots for the lawyers who are listening to do, and lots also for their clients to do. I think we've got more than a handful of questions from both lawyers and clients, and if we could just cherry pick a few of them. One that has come up more than once is, does the Act cover student accommodation if over 18 meters or 7 stories or more in scope? What do you think about that, David Hopkins?
Certainly, there's no reason to think they're not. If they are residential, which presumably student accommodation is, no matter how shoddy or dirty or whatever it is, it nonetheless contains more than 2 residential units. And so, yes, student accommodation is covered.
Thank you. And a market-directed question, Paul. BSA has great intentions and focusing the industry's mind on liability, particularly refire claims. But since the PII industry seems to be gradually removing much PII coverage for consultants and contractors, might it in part have created shallow remedies in reality if defects arise from design flaws?
I think that's one of the potential unintended consequences, that the people who are, it's all well to get judgments against people, they have to be enforceable. And insurance is obviously tightening up as a consequence of it. But I think that the mood the government are in, if that happens, they'll just pass some more acts stopping the insurers from withdrawing cover or things like that. That's very much the entire mood. But I think that it's right that what you will see is much more thought and skill as to where, in fact, the assets really are, rather than which companies are liable.
And this is quite fun because I can throw questions at people who may or may not be able to answer them. David Sawtell,
you can answer anything, don't worry, he's fine.
If there are multiple accountable persons, is that not at odds with the objectives of the Act to ensure that leaseholders do not find themselves in the middle of disputes between contractors, developers, and building management companies?
Yes, absolutely. That's been one of the concerns being raised in the debate about the Act. There will potentially be a number of accountable persons, and then there might well be debate as to how it carries the obligations of the principal accountable person, and then little guidance. So unfortunately, Part 4 of the Act does seem to create conflict in some circumstances between different parties that leaseholders might find themselves affected by. I agree.
And the history of the industry over the years has been very much for, when there are multi-defendants, very much for the defendants to wait till just before the trial to get their act together collectively so as to sort themselves out. I did many housing estate cases where there was a contractor, consulting engineer, ground conditions remediator, where it was plain even then that the house owners were going to win against somebody, and that somebody would have enough money to pay. But it was only, months before trial that the defendants collectively were able to grip it, because the sharing of responsibility is one of the problems that the one of the problems that we haven't really grappled with. Of course, that's going to become even more important because with these long limitation periods, against some but not others, contribution and whether the Act applies, and then the 2-year limitation period from resolution of liability. So I think multi-defendant issues, if I was trying to do a sort of pick of things that were going to occupy the lawyers, apportionment stroke identification of right defendant would be right up there for me.
And of course, the question of claims made cover for insurance will have to be reviewed when one's looking at that kind of limitation period. A question for, well, for Sam to begin with, and I think David Sawtell as well. Will the registration of HRBs with the BSR between April and October 2023 require a completed safety case, and how is BSR going to resource that?
Yeah, well, I think the second part of that question is on all of our lips, and only time will tell. In terms of what registration requirements will be imposed, as with many parts of the Act, there is provision in the Act for secondary legislation to be introduced to set out exactly what the registration requirements will be when you're registering a higher risk building. So I'm sorry that's a bit of an unsatisfactory answer of watch this space.
David, anything to add? David Sawtell?
I completely agree with that. There's so much secondary legislation, and then looking through the enactment process, it won't be something we know until slightly later on when the draft regulations become clearer.
And a linked but different question, is there still a building safety charge in the Act, or did this not make it through? And what happens about paying for remediation of non-historical defects, David Sawtell?
As I understand it, the current regime anticipates there will still be a building safety levy at which will be payable at Gateway 2, i.e. before construction works begins. That has still yet to be fleshed out in other secondary legislation. A very unsatisfactory answer, but that's all I can work with at the moment. In terms of historic defects, the Building Safety Act has so many provisions in respect to what we might call historic defects. It's going to be like solving a jigsaw puzzle in terms of whether or not we find a defect, whether we can get it through into the 72 Act, try and find something otherwise under construction product. And we've barely touched upon the new regime for liability for construction products, especially cladding products. So it's again, this is not an overall Australian style resolution to the problem. This is a case of multiple different regimes with multiple different definitions of what is a high risk building throughout the Act. And it's going to be case by case.
Thank you.
I can just add that there's the building safety charge that was envisaged and actually in earlier drafts of the bill, that has actually been removed. So what that was going to be requiring leaseholders with leases of 7 years or more in higher risk buildings to be liable to pay building safety costs through a service charge. So that specifically has gone. It's not in the final version of the Act, at least not that I could find it, but everything else David said is in there.
Excellent. I'd like to thank the participant who's made an observation that perhaps project insurance will become more of a norm as it can ease some of the sharing and attribution and contribution issues that Paul mentioned. Do you agree with that, Paul?
Definitely.
Yeah.
I think that's. It'll be a sort of both a positive and non-negative response in the sense that the industry will want to push that sort of cover. But secondly, I think it's always been a good idea on these big projects. But these sorts of questions, both the regulation during construction, problems thereafter and claims thereafter, project insurance is, in my view, a very good thing generally, but here is going to be a great help.
Thank you. Well, it just remains for me to thank all of you for attending, and it looks to me like something like 95% have stayed with us for the hour. So thank you very much for that. Thank you to the contributors from 39. And we have a number of unanswered questions, and insofar as we can, and I'm not sure what we do about the anonymous ones, but we'll try and answer those. It may be we just answer it and put it on the website alongside the link to the recorded webinar, but we'll try to answer them in one way or another. So thank you from all of us, and we're going to sign off.
Good luck, everyone. It's a nightmare.
Thank you.
Bye.